My name is Kristen McCall, and with my colleagues David Tackaw and Kate Crosby, I've been serving as a leader and organizer of the Kentucky Lawyer ACS chapter. I also want to thank our co-sponsors for this event, the At-Large, Chicago, Georgia, Nashville, New York, Northeast Ohio, and DC Lawyer chapters, as well as the George Washington Law School student chapter. For those of you who do not know, the American Constitution Society is the nation's largest progressive legal network. ACS believes that the Constitution is of the people, by the people, and for the people. We interpret the Constitution based on its text and against the backdrop of history and lived experience. Through a diverse nationwide network of progressive lawyers, law students, judges, scholars, and many others, we work to uphold the Constitution in the 21st century by ensuring that the law is a force for protecting our democracy and the public interest, and for improving people's lives. We hope you'll continue to engage with ACS and connect with our nationwide network of progressive advocates, activists, and thought leaders, and build relationships that will support you throughout your career. We look forward to working with you to advocate for racial justice, gender equality, immigrant rights, climate justice, and a constitution that works for all people. Throughout the program, we encourage you to submit your questions to our panelists and to our other speakers through the Q&A box. And without further ado, I would like to introduce Sam Aguiar, founding attorney of Sam Aguiar Injury Lawyers and an attorney for Brianna Taylor's family, to speak about what happened to Brianna Taylor.
Hey, everybody. Thanks for having me. I am super excited to be here, and I'm super excited to be working with a tremendous panel today. We got some politicians, we got some lawyers, so we got some talkers. So let me see how quickly I can get through this. We could talk about Brianna Taylor and the facts for hours, but frankly, I'll try to keep it to the nuts and bolts, and I'll try to not be too vanilla about it, because most people know about the general circumstances surrounding the murder of Brianna Taylor. I was privileged to get on this case right away. I got a phone call literally the day it happened, where the indication to me was, hey, our daughter's dead. Somebody shot at the police, and the police shot back, and Brianna was caught in the crossfire and died. And obviously right there, as an attorney who handles civil rights cases from time to time, there were some red flags right away that made me a little apprehensive to learn more about the case. You hear that fact pattern, it's like, whoa, you got some cops that are shot at, they shoot back, they're justified, it's self-defense claim. And this is a tough case right here. And, with the onset of COVID and everything else, we knew that it was going to be a situation that would be even tougher. But also with those red flags associated with the description were red flags associated with the incident. And I can tell you that I was out of town. So I got back into town a week later, and you got to walk through that apartment. And that's something that I'll never forget. There were bullet holes everywhere. And I mean everywhere. We're talking about a 900 square foot apartment. And at least to date, there have been disclosed 34 gunshots. I wouldn't be surprised if it was well more than that. And we're walking through, and you got these bullets in every room. You've got a situation where they go through the wall. You got these windows. You got a screen door that's been replaced. And you start wondering, what the hell happened here? Why did they need to fire so many shots, and what went down? Fast forward, we've got COVID going on for a couple of months. We're sending out open records requests. And one of the things that I've been fortunate enough to acquire in these cases are good sources. And so, you start asking questions, and you start hearing, hey, one guy apparently shot outside blindly. He didn't know what the hell he was shooting at. You hear another one that says, hey, you want to look into this search warrant and why they were there to begin with. And you start hearing some misinformation come out. Brianna was allegedly asleep, according to a lot of people walking through the apartment. You could see that wasn't the case. But you also don't see any blood in the front where this officer was supposedly shot in the femoral artery. And you start wondering if the story really adds up. So we started doing some due diligence. We knew as soon as we sent out an open records request for information, and we got a lot of pushback that this was a lot more than what we were being told. Come to find out that this was a situation that the story certainly didn't start on March 13th or even March 12th of 2020. It was a story that started to take place in December. And what you find out is that there was a couple of houses across town, well far away from Brianna's place, where there were basically a police unit was formed to clear this house out. It's part of a development that's going in. So there's a lot of components to this case, with gentrification being one of them. And then you start to see some of the really rogue and aggressive police tactics that were taking place to try to force these people out. Brianna happened to be the ex-girlfriend of the main target that they were going after, and they ended up really going covert with this guy. They had a pole camera on him, watching him 24 hours a day. They put a GPS tracker on his vehicle. One of the things that didn't really come out that I'm surprised it wasn't a bigger story was that they were getting search warrants to ping and have a pen register on his phones, but they also got one for Brianna's phone and misrepresented to a judge that it was Jamarcus Glover's phone. So basically and also, they were getting search warrants for his vehicle. They were getting all these other search warrants. And the search warrant that everybody's heard about for Breonna Taylor's home on March 12th that misrepresented that a U.S. postal inspector had verified that suspicious packages were going to Brianna's home. They're being picked up by Jamarcus Glover. That was actually put in 3 different search warrants beginning in February. So one of the things that's ongoing right now is an FBI investigation, and we're really monitoring that. When we fast forward and go out of sequence here, we know that there was a real lack of accountability from the Attorney General's office as it related to these officers and holding them accountable criminally, even when a grand jury was prepared to do that. We're really hoping that the FBI cracks down on federal civil rights violations. So Brianna Taylor is at home. The records and documentation show, and obviously LMPD knew this because they were monitoring her cell phone without telling anybody, that she had become serious with another ex-boyfriend shortly after Valentine's Day. She didn't have any contact with the ex-boyfriend, and she was really out of the equation. But for some reason, something happened to where these LMPD detectives in this unit decided that they needed really to get a warrant on her place as a contingency for that night, because Jamarcus Glover was bouncing around from different places. And to this day, we think that was just a backup search warrant. On that particular night, they did have somebody that was surveilling the home, and they would have identified in surveilling that home the presence of a black male. They would have identified the presence of a black Chrysler 300, which happened to match one of the suspect's vehicles by coincidence. And certainly we think that's why they ended up hitting the house. Jamarcus Glover was MIA at about 11:30 that night. He was actually at the mother of his child's house. And we think that because of that, they went into panic mode. The search warrants weren't going to be able to execute it on time. And even if they hit the house they were going to, at that point, at least their inclination was that they were going to get everybody but their main target. There's certainly conflicting stories. By the end of the day, between the FBI, the Attorney General's office, LMPD, and our office, there are 37 neighbors that will conclusively state that they never heard these officers announce themselves before making entry into the house. And we've also gone through a study where 70 different search warrants were evaluated by a PhD student at the University of Louisville. He was following plainclothes narcotics detectives with their consent, and they went 0 for 70 on knocking before they actually hit the door with the ram. So we feel pretty good about the fact that there was no announcing, because that's their pattern and practice. And frankly, I think these officers, if they ever told the truth, would say that they don't feel safe announcing themselves beforehand. They'd rather just announce concurrent with the ram. I don't have much time here. So frankly, I could keep going, but the rest is, I don't want to say history, because certainly there's a narrative that's out there that isn't 100% conclusive in terms of facts. We know that officers made entry. We know that a shot was fired. We know that 33 were fired in return. We know that at least 10 of them were fired because we ended up hiring our own ballistics expert, one of the best in the country in Arizona. So we know that at least 10 of them were fired at Brianna in her direction while she was going to the ground and while she was on the ground. We also know that under Kentucky law, these officers don't get a self-defense protection if they're required to knock and announce and don't do so. Basically, at that point, because they're not authorized under the law to make entry without announcing, they're considered the initial aggressor. and that's one of the situations here, I guess, from a constitutional perspective, and we look at the Fourth Amendment in particular, that we've got some issues with. And to be clear too, I guess to clear up any sort of factual discrepancies here, there's no dispute that that search warrant was initially obtained as a no-knock search warrant. We could again talk for hours about no-knock search warrants. There's no dispute that it was converted to a knock and announce warrant prior to entry being made into the home. There are so many other elements of this case that we could talk about. There are so many other factual, pieces of information that are probably worthy of discussion. But I'm going to go ahead and defer to my colleagues. And certainly when the Q&A time comes, my role in this case primarily was to be, the architect, behind the scenes, the litigator, to really discover all the facts. So I could clear up anything that y'all need later on. And with that, I will turn it over, and thank you for having me.
Thank you so much, Sam. And now I'd like to introduce Jamiles Lardy, who is a staff writer at the Marshall Project, who will be moderating our panel.
Hey, everybody. Thank you so much for having me here. As a storyteller by trade, I just want to start by saying how important I think it is to start with Brianna's story before we jump into today's topic, which is reform and looking ahead and moving forward. We have a very distinguished panel here that I'm going to introduce briefly before we get into the discussion, starting with Cami Chavis. She's got a lot of titles here, so give me a second. Associate Provost for Academic Affairs, the Director of the Criminal Justice Program, Professor of Law, and ACS Faculty Advisor at the Wake Forest University School of Law. We have the Honorable Lisa Madigan, who is a partner at Kirkland & Ellis LLP, and the former Attorney General of the state of Illinois. And then we have the Honorable Attica Scott, a Kentucky state representative and a sponsor of Brianna's Law in Kentucky, which I'm sure we're going to speak more about. I'd like to first turn to AG Lisa Madigan on what do you think the role of state AGs in police oversight and accountability currently is? Obviously, it varies from jurisdiction to jurisdiction, but what is it today, and what should it be?
So that's a terrific question, but let me start by saying thank you to ACS for organizing the panel, and thank you to everybody who's here participating in the panel as well as watching for demonstrating your commitment and your interest to extensive police reform, which I think we can all agree is absolutely imperative across our country. To directly answer your question, state AGs, for the most part, over the years, have really been one step removed from a lot of the reform efforts that have taken place. And partly the reason for that is historical. So in 1994, in the aftermath of the brutal beating that was captured on video of Rodney King in Los Angeles, Congress passed a law that gave the authority to the U.S. Department of Justice to engage in pattern and practice investigations. And that has been used over, well, I'd say probably approximately 70 times since 1994 through 2017. And so for the most part, when there were demands from the public, when there were incidents that cried out for investigation, you really had the ability of somebody from DC coming in to a jurisdiction and being able to conduct an independent investigation. The authority that the Department of Justice had, in addition to being able to investigate, also gave them the ability to resolve circumstances when there were constitutional violations that were found. And so that is what we saw time and time again with consent decrees being entered around the country in jurisdictions where there was a need for police reform. Now, what has happened is that there are a growing number of states, California being the one that was actually way ahead of the game, who have now either asked for or received the authority to conduct pattern and practice investigations to deal with police reforms locally. Now, interestingly, in Chicago, and the reason that you all invited me to participate is that our history here, it's another terrible tragedy, a murder of a 17-year-old African-American man by the name of Laquan Mcdonald that took place in October of 2014. And the video of which was not released until over a year later in November of 2015. That when it was shown demonstrated that Laquan Mcdonald did not pose a threat to the officer who killed him, nor the other officers that were on the scene. And instead, he was walking away. And it was really at that point, and it was that video that, you know, even though there had already been 50 years of well-documented, well-known police brutality, use of excessive and deadly force, primarily against African Americans, that video demonstrated, you know, it was no longer a he said, she said situation, but it was truly a he said, but we all saw what happened situation. And so in the aftermath of that video being released, the Department of Justice did agree to come to Chicago and do an investigation, pattern and practice investigation of the Chicago Police Department. But a week after they issued their findings, their report and their recommendations, the administration changed. And when President Trump came in, along with Attorney General Sessions and later Attorney General Barr, they announced a change in policy that in essence said policing matters should be dealt with at a state and local level. And so, you know, what they really did was essentially abdicate their responsibility under the law to go in and to do these pattern and practice investigations that will result in consent decrees and lead to meaningful police reform. And that's where, as the Attorney General of Illinois at the time, I stepped in to say, we have a moral imperative here. We have a report from the Department of Justice that has approximately 100 recommendations for reform. We have a public demand for real change. And we engaged in a lot of research, but also a battle with the city of Chicago and the mayor to make sure that instead of entering into what we learned was going to turn out to be a legally unenforceable memorandum of agreement, that I ultimately was put in the position of having to file a lawsuit against the city of Chicago so as to force negotiations around police reform in the form of a consent decree. That we did over a period of a little under a year. We released it to the public. We had community roundtables, and we should talk more about some of the public engagement as we go on. But in the aftermath of being able to have our consent decree entered in January, towards the end of January of 2019, I've really been promoting the use and ability of state AGs to go in and to do these types of pattern and practice investigations to uncover unconstitutional policing so that we don't have to wait, or we should not be in a position when you have different administrations and there are different priorities to truly be able to address police reform. And so while we're very hopeful right now with the change in administration that we're going to get a beefed up Civil Rights Division of the Department of Justice, the reality is, there are many jurisdictions, and as we saw over the summer, there is no time to waste. Every day that we go without meaningful police reform is another day where people are potentially going to lose their lives. And we don't want to see that happen in this country. It is unconscionable.
Thank you. And let me ask you this. Now, what is the connection, and I suppose the disconnection between patterns and practices investigations and the investigations and potential criminal charges of specific critical incidents, right? I think about, for example, the Ferguson report, which was in fact 2 reports, right? There was a report about the interaction between Mike Brown and Darren Wilson that day. And there was also a sort of broader report that talked about the relationship between the department and some of the ways in which policing there was unconstitutional and was contributing to this revenue, generating system, right? So an individual act of potentially unconstitutional or maybe criminal policing does not necessarily have to occur in the setting of a pattern and practice of unconstitutional policing, right?
Right. And I think, unfortunately, what we've seen over the years is there will be, a crime committed. There will be an excessive or deadly use of force in some way. And again, it's handled as a one bad apple circumstance, or one thing went wrong in this situation, as opposed to the pattern and practice. Here in the city of Chicago, my experience over 50 years has been, we have had repeated commissions, repeated reports, findings, recommendations, lawsuits, settlements. It's not just one person or a group of bad apples. When you actually investigate and do so looking for that pattern, what you find is there are poor policies, there is insufficient training, there's a lack of accountability and discipline. There's not an embrace of community policing. It goes on and on. And once you see that, you can no longer blame it on one individual or a small group of individuals, but instead you really, I think, are forced to reckon with the entire system and make those fundamental, systemic, sustainable changes.
Yeah, and your point is well taken, but I think what some people may be wondering is how big a piece of the puzzle of addressing police violence should criminal accountability after the fact be or not be?
Yeah, I mean, look, so I'm going to say this. Government is very reactive. Government is not, unfortunately, and the representative can speak to this a little bit, is not always proactive. And so, unfortunately, it has taken these terrible, in the videos, right? The evidence of these terrible murders being committed by law enforcement officers to force change. And the real change has also only come about when the public has been engaged, when they have been in the streets and they have demanded reform. And so could it be a piece of what happens in the aftermath of these indictments and prosecutions? Yes, but is that typically how it has taken place? Unfortunately, not. And so now we're in a circumstance where, the murder of George Floyd, the murder of Breonna Taylor, the murder of Laquan Mcdonald, and so many other people, it's been deemed intolerable by the majority of our society. And that is what is going to drive this real change in policing.
Thank you so much. And that's really a terrific segue to Rep. Scott, who was involved in the legislative process of drafting and passing Brianna's law. I was hoping, Representative Scott, that you could tell us a little bit about that law. What does it do? What doesn't it do? And maybe some of your observations from working through that process.
Definitely. And want to affirm my friend Sam Aguiar and the work that he's been doing. We go way back, and I'm going to be one of those people who says we've been trying to do this work for a long time and people just wouldn't listen. My first session in our state legislature, before I even had a chance to take a sip of water, Sam was contacting me and saying we need to work together on some legislation around independent investigations of police shootings. So I do want to say that Brianna's law in Louisville, Kentucky, passed unanimously on Louisville Metro Council back in June. I and Sam and other folks, including the ACLU of Kentucky, are working on Brianna's law for Kentucky to cover the entire Commonwealth. So the bill hasn't yet had a hearing in committee. We go back for part 2 next month. But really, it grew out of the movement for justice for Brianna Taylor, a movement that has seen more than 700 people like myself and my daughter unjustly arrested, a movement that has seen us on the second night of protests back in May, tear gassed, and in June, hit with long-range assault devices. In July, experiencing being kettled by police. And in August is when we filed Brianna's law for Kentucky. We currently have nearly 5,000 community co-sponsors. We wanted to do something different with legislation that we've never done in Kentucky before. And it was really inspired by Senator Kearney in Pennsylvania, who also filed Brianna's law, but to get community folks to say that, yes, we need this in Kentucky. So nearly 5,000 people have said that. And we also have 13 legislative co-sponsors who've signed on to Brianna's law. And what Brianna's law would do is restrict the use of no-knock search warrants. It would also mandate video recording of when search warrants are being issued, and it would also require officers to go through alcohol and drug testing after shooting or other violent incidents. So those are the three main components of Brianna's law. We're working right now to get the bill heard in committee and then onto the House floor for passage. We also know that we have some different realities here in Kentucky than maybe some other states have. We have a legislature that's deeply rooted in institutional and systemic racism. No member of the Legislative Black Caucus has had a bill heard in going on 3 legislative sessions now, so 3 years. And we also know that, at least in my research, there's not one piece of legislation in the Commonwealth of Kentucky that bears the name of a Black person. And so to have Breonna Taylor's memory and legacy to be codified with Brianna's law would be huge, and we've never had that before. So we know that we are up against all of that. We also know that we're up against a system that decided in September to arrest me and my daughter for fighting for justice for Breonna Taylor, charge us with a felony rioting charge, Class D felony. Class D felony, the same as one of the officers who murdered her. And we spent 10 times as much time in jail than he did. So those are our realities that we face. I will continue to work with Sam and other folks on Brianna's law for Kentucky. As my daughter reminds me often, we don't move in fear. So we're going to continue to keep pushing forward and pushing onward with everlasting resistance. We know that there's much more work that has to be done besides Brianna's law, but we also know this movement for justice for Breonna Taylor includes protest, it includes policy, and it includes politics. We already have folks who've been out on the front line who are planning to run for office in 2022 because they see that we can't wait on or depend on people who are part of the status quo to liberate Black people, because that's not how it works. And we also know that we've got some real work to do around policing. This is a system that was never designed for Black people except to keep us enslaved. So we're working on issues like what it means and what it looks like to defund police, to reallocate those funds to meet the economic and social needs of communities, and dismantle this racist system that is killing our people. So that's where we are in our work on the front lines for justice here in Louisville, Kentucky.
Thank you so much. And so the bill that you are currently working on, what are the limitations on no-knock raids under that legislation?
So for us, we do allow for exigent circumstances. So circumstances where, for example, a child might be held hostage, or it might be a domestic terrorist situation. But for drug offenses, for a no-knock search warrant for drugs, we removed that. We have a restriction on that in Brianna's law for Kentucky because, quite frankly, law enforcement officer's life shouldn't be in danger, and the person whose home is being invaded shouldn't be in danger because they might be trying to flush some evidence down the toilet. Yeah. So those are our restrictions.
And just for context for folks, historically, the notion that a suspect in a drug investigation may be destroying evidence, aka flushing drugs down the toilet, has been the reason why courts have granted this notion of exigent circumstances in drug cases for no-knock warrants. And I want to stay on that for a moment. And I think I have a sense of what your answer to this will be based on your comments, but is restricting or even banning no-knock raids enough, right? I mean, if we think about the fact that police can knock and announce with no statutorily defined minimum waiting period, right? Knock, 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 police, burst in. That's not necessarily a no-knock warrant, but it could achieve, the same outcome, the same tragic outcome could happen. Are there other avenues that we need to be looking on beyond no knocks, and is there some extent to which no knocks have become maybe too much of a focus?
Well, for us in Kentucky, it's not too much of a focus because, there are a number of other states across the country that already restrict the use of no-knock search warrants. Kentucky is behind with those states, but yet we've seen our sister Commonwealth, Virginia, pass restrictions on no-knock search warrants. We've seen Pennsylvania, another Commonwealth that's already had a senator who's filed Breonna's law there. So we're seeing where more and more states, Florida, Oregon, already passed similar legislation years ago. So we've seen other states already do this. Kentucky's playing catch up and at the expense of people's lives, literally. So for me, it's not the end. It's not the only thing that we need to do at all. As Sam knows, we're working on addressing the Police Bill of Rights here in Kentucky. One of my colleagues is working on that because, you know, some people might not even know that there's legislation that protects rights for police officers and often goes to the extreme to the point that they're not held accountable for their actions. So there's a lot that we're addressing. We're also addressing the violent actions of police toward protesters. So there's a lot more that needs to be done, but we also know that the call to action for many people was the murder of Brianna Taylor. And so we're addressing the issues that came out of her murder and this movement for justice.
Thank you. Okay, if I jump in here too for a second?
Please, Sam.
Cool. Yeah, no, because that was a great question. A couple of things that you brought up. First and foremost, what Brianna's law would do, and what all legislation in this matter has to do, it imposes a statutory required minimum amount of time for a warrant to be considered executed as a knock and announce warrant. 15 seconds here minus exigent circumstances. And exigent circumstances is a term I hate, but you have to have it in there to generate bipartisan support, because otherwise you're going to find somebody give a hypothetical situation where 15 seconds just doesn't cut it. But they have to give a compelling reason. It is their burden to demonstrate that it's an exigent circumstance. The second thing that we've seen so much is this bipartisan and basically unified agreement that no amount of drugs is worth human life. And I think that that is a phrase that people need to keep emphasizing when they are acting as proponents for search warrant reform, because once you put it in perspective and once you realize that you're going into these houses, and Brianna's law also goes into seizures, things along those lines, because a lot of the motivation, unfortunately, with nefarious cops is that they're going to go in and hit a gold mine of drugs and cash, and that maybe only some of it's going to get reported. But you have to keep emphasizing no human life is worth any amount of drugs. So I think that right now is kind of the governing theme that we're trying to remind people of, that we're going in Louisville alone, we're going into over 1,500 homes a year because we think that there's some dope in there. So 1,500 doors are being broken down a year in Louisville just because they think there's some dope in there. And, you know, Representative Scott and I are hoping that stops.
Yeah. And, you know, there are a lot of examples of law enforcement officers being shot at, being hurt, being killed, you know, while executing no-knock warrants, especially because there's this, you know, this castle doctrine that we have in the United States. People are defending their homes rightfully. And, you know, I'm curious to know from either of you, because, you know, this is not new. This has been happening throughout, you know, since the beginning, since America started fighting the drug war. We've had no-knock warrants. We've had some of the risk that poses both to citizens and to law enforcement officials. Has there been any support from the law enforcement community to pare back the use of no-knock warrants? I mean, has there been any buy-in from those folks that you're aware of?
Well, I'll say for Kentucky, yes, we have in Bowling Green, Kentucky, the police chief there has already restricted the use of no-knock warrants. In Glasgow, Kentucky, the police chief there has already restricted the use of no-knock warrants. But the thing is, it shouldn't have to be done piecemeal like that. We have 120 counties in Kentucky. Each one of those municipalities shouldn't have to take it upon themselves to one by one over the course of the next few years address this policy. It should be statewide legislation that restricts the use of no-knock warrants across the board. And so that's why we're working on this statewide legislation. There are police chiefs across Kentucky who do support restricting the use of no-knock warrants, but predictably, the Fraternal Order of Police opposes Breonna's law for Kentucky, and they haven't really given a good reason why. Yeah.
The federal government, of course, cannot tell states, certainly not the president alone, cannot tell states how to police Joe Biden did float during the election campaign, cutting off JAG burn grants for departments who did not ban no-knock warrants. Is that something that you think would be helpful?
Yes, you take you take the money away from a department, and unfortunately, it's kind of like civil litigation. Did Brianna Taylor, did the $12 million settlement only benefit the family? Absolutely not. It hit the city where it hurts, and it makes them second guess the decisions that they're going to make. And that's a society that we live in. Unfortunately, you got to do whatever you can to show what's going to be a deterrent. It's kind of like other cases where we go for punitive damages. In a situation like this, if you hit them where it hurts, they're going to think twice about doing it again. So yeah, absolutely.
Professor,
I also find that Sam and I have been working on making sure that law enforcement and the city is responsible for the damage that they do to someone's property. I have other constituents in my district who the police were looking for the wrong people who had moved out of this house 3 months earlier and busted in their door, and then just got to walk away and throw their hands up. And now this family, who's living paycheck to paycheck, is responsible for repairing the door on their house. So Sam's absolutely right. You got to hit those budgets in order to sometimes make people pay attention.
Yeah, for real numbers here. The city of Louisville's budget for the fiscal year 2021 is $600 million, give or take. The police budget is $200 million. Brianna Taylor's $12 million settlement, $7 million of that hits the general budget, but that $7 million does not come out of the police budget. So I think that some of the talk nationwide needs to be, hey, again, hit them where it hurts. If 1/3 of your city budget goes towards the operations of a police department, then can't that budget right there shoulder the burden of any settlements that are being paid out of their conduct? Split the baby if you need to, but you need to do something there to show them that they're not going to be able to have their toys or their tanks or some of these other things if they engage in activities like this that take people's lives.
Thank you, Sam. Professor Chavis, I would love to turn to you and turn the discussion to independent prosecutors. I'm curious if you have any thoughts on, what is the importance of independent prosecutors in cases of police violence, and what the standards should be for appointing those prosecutors.
Great, thank you, and thank ACS for having this program. And we need to continue to talk about what happened to Brianna Taylor and so many other unarmed folks around the country. And it's been happening for decades, and we know why it happens, and we just need to have some transformative change within our police departments. I will talk about independent prosecutors, but I want to also address some of the things that have been said. I mean, first of all, there's no question that we need transformative change in policing in the United States at every single level. When you look at the use of force, and whether it's an officer placing their hands on somebody, and you can go down the entire continuum of force, using their baton, using less than lethal means, and then all the way to shooting someone. Police officers police Black communities and Black bodies differently than they police others. When you look at that spectrum of force, disproportionately force is used against African American, Blacks, and Latinos in this country. And so when you talk about a no-knock warrant, and the violence, the sheer and utter violence that happened on the night that Brianna Taylor was killed, when the police killed her, it's not a mistake, and it's not happenstance. So we really have to, I just want to say that we have to have the transformative change. And I say that because I'm going to talk about the role of independent prosecutors, and it's important. But this addresses something, Jamilis, that you talked about earlier: the importance of a criminal prosecution. A criminal prosecution is something that happens after someone a life has already been taken, or excessive force has been used, and we really have to think about what can happen to prevent that. And so I have a little bit of a different take, I think, on some of the things that can happen proactively, and some things that we know can work. And it's really rooted in the pattern of practice authority that was discussed before. But when we think about, so when we do think about independent investigations, independent prosecutors, so I think about them as part of just one tool in the entire toolkit of police accountability. And of course, it is important for prosecutors to a lot of groups, including President Obama's 21st Century Task Force on Policing, recommended that you have independent investigations and prosecutors. So when we think about what's happened in this country, there's a lot of different reasons why people say that a local police department cannot or should not prosecute a police officer when there's been an excessive use of force or deadly use of force. And the first thing they say is, police officers have this really close working relationship with the local police officers. It's true. They rely, I'm a former prosecutor, rely on the police in that local community to make your cases. But I think that, and so there's this idea that there is an inherent conflict of interest when you have a local prosecutor that's investigating the local police. And also there's the idea that prosecutors have an ethical obligation to refrain from bringing charges they think they can't prove. And so we know that police officers historically have been seen by some members of the community as sympathetic, and I'm using my air quotes, sympathetic victims, or sympathetic, not victims, but sympathetic actors in a situation. And so I think that, and so a lot of times prosecutors are saying, well, if I bring this, I'm not going to be able to secure a conviction, so my ethical obligation. And I think what we see sometimes is prosecutors substituting their own judgment for that of the jury. And really part of this is our culture. And again, it's part of the culture that we have to change to say what Sam was saying earlier. It's not okay to risk the loss of life, whether it's an officer's life or an alleged a suspect's life, when the issue is drugs. So that's another thing. And then the other issue when we think about why it's been difficult to secure convictions in this space, and there are a paltry number of charges that are brought at the state level, and of course a paltry number of even federal prosecutions that are brought when we're thinking about prosecutions for police. But at the state level, their politics, inherently politics are involved. If you are a local elected DA, it is very difficult for you to think about. And this cuts both ways, because we could see it in the Michael Brown death. The prosecutor McCulloch there, he brought the case to the grand jury, and in a form and in a fashion that many of us who study this did not understand. Well, what were you doing? It was so flawed, the grand jury process there. And it's very easy, should be easy to, folks have heard the old adage, you can, a grand jury will indict a ham sandwich. It's because the prosecutor knows kind of what they need to bring in order to secure that indictment. So we see sometimes prosecutors using the grand jury as a shield, and they really get to control the information that the grand jury sees, and so they know what charges are likely to be brought or not. And so it can work that way. There's another way we actually saw in the case in Baltimore in the Freddie Gray case, an elected prosecutor there, and a lot of experts have thought that maybe those officers, and because they did not secure convictions, were overcharged in some sense, and was politics involved there. So that is, for all of those reasons, it can be complicated for local prosecutors to be involved in these cases. So, so what do we do about that? And there've been a number of different. Well, I want to talk about the harm, I guess, of having these either prosecutions that are never brought, or these failed attempts with the grand jury. And what happens is, what we really see is an undermining the rationale of criminal law. I teach first year criminal law students, and we spend a lot of time going through the underlying rationale for punishment. You want specific deterrence. If you have committed a crime, I don't want you to commit the same crime again. General deterrence. If you've committed this crime, I can't have everybody else out here thinking that it's okay for you you did it, and so it's okay for them to do it. The same thing is true when we're thinking about police officers. We have to go back to the, so this goes to Jamila's, your question earlier. It is important that officers who violate the law be held accountable, because it undermines, if police officers are lawless, then what can we expect of the general population? And so there's a feeling, there's a feeling that police officers are not asked to, or not properly held accountable through the criminal justice system. So the underlying rationale of criminal law, I always go back to that. And what does this do? It causes an incredible lack of trust, and undermines the confidence that the public has in police and in our entire criminal justice system. And so when people, as I think about having been an actor in the criminal justice system, I see way too many Black and brown people incarcerated for nonviolent, for these drug offenses. But at the same time, I believe that there is a place for our criminal justice system, because when someone does what they did to Breonna Taylor, I would want them to be held accountable under that same system. So we have to do something to maintain our trust and confidence in the criminal justice system. There are a lot of benefits, I think, that again, when you have a more independent prosecution, if you are able to achieve an independent prosecution, and I'll talk about some examples of how you can do that. But when people see that police are being prosecuted and held responsible for upholding, when they're being held responsible for their actions, then perhaps other police officers or police agencies began to think about their practices and transforming their practices. Also, at the same time, I think we can, if you have an independent prosecution, we can avoid overzealous prosecutors who are just trying to satisfy the public, because ethically, that's not correct either. And then, I think having independent investigations and prosecutions can lead to more transparency and trust. And how do we do this? There are a number of and again, this is where I would take issue a little bit with what's been said about, oh, let's use a stick, right? Let's take the money away. Actually, I think it might be more impactful, more effective to incentivize, to give grants. If I were the federal government, and I've written about this before, to give grants, give money for states to create more creative ways to address police accountability. And we have to set a floor. It can't just be anything. But if we set a floor, and the pattern or practice cases have given us so much information as to how we can increase police accountability in our local jurisdictions.
Amy, can I jump in for a second?
Yeah.
I wanted to ask, when we talk about independent in investigations and prosecutions, what from your vantage point is the correct amount of the appropriate amount of distance to make it independent, right? So is getting a DA from the next jurisdiction over, does that work? Or the state AG, or should it be federal? Should we be relying on the federal government to do this? Like where do we draw those lines?
Well, so then that's what I was actually going to talk about, the different models that we can use. One model, of course, is removing it up to the state AG's office. But again, if you have a state AG that is elected, and this is the case with Daniel Cameron in Kentucky, that may or may not necessarily get you the level of independence that's going to satisfy the public, to say that there's no inherent conflict of interest. So as I was saying, I would have again, the federal government can give money to incentivize this. There's several states that have legislation that would create an entirely independent body, basically a body, a pool, an office of prosecutors. Maybe they act within the AG's office, maybe they are outside of it. But prosecutors, and this, I'm thinking of the model in New York, for example, in 2015, Governor Cuomo signed an executive order creating a special office that is full of seasoned prosecutors who can investigate these cases and work that way. There, of course, having you could appoint a federal prosecutor to enforce the state law. You would need permission from the state to allow those federal prosecutors to do that. But that is another way to do it. I think that Connecticut has another model where, again, it's automatic, where if a police officer has shot someone, then automatically it goes to an independent prosecutor, again, a seasoned prosecutor. But there's some shortcomings of these proposals as well that, I'm happy to talk about in the Q&A. But I think that when we think about this, if you have a centralized body at like a state level, this body can issue reports, recommendations for what they're seeing across the state in these cases. But I guess finally, what I'd just like to say is that, again, there are a number of benefits to these independent prosecutions. I don't think our system is going to suffer more if we have them. I think it would be improved, but I also just want to remind everyone there's so many different components, and an independent prosecution is just one small piece of it. And we really have to have, in order to have the transformative change, we have to have all of these tools working together, and we have to prevent the conduct before it happens.
Thank you so much, Kami. I really want to thank everyone for being here. We're not done yet. If you have any questions for our panelists, I'd love it if you could submit them through the Q&A box now. We have a couple that have already come in. The first one is it sort of touches on this this question of oversight and prosecution at the federal level. The question notes that the FBI got involved in the Breonna Taylor case, looking at civil rights violations, but there are a finite number of cases that the FBI actually looks at, absent media attention. How important should, in your opinion, media attention be in whether federal authorities step in? And I'd love to just add a little bit of context to this question. I was one of the reporters on the team at The Guardian who worked on a project called The Counted, where we were keeping track of everyone who was killed by the police in 2015 and 2016. And one of the observations that I made from sort of working with that data, working with those stories every single day, was that there seemed to be not a whole lot of rhyme or reason to which cases sort of captured the public's attention and interest, and which cases just sort of vanished into obscurity with minimal coverage or attention. So that's an observation, but I would love if anyone had a response for our questioner.
So to the extent that the question seems to be focused on, media attention, and should that be, a factor in whether or not there's an FBI or an outside investigation done, I would say this, of course it shouldn't be, but that is the reality, right? The reality is there has to be attention drawn to injustices so that there is the support, or the elected officials who are supposed to be representing the people, will devote the time and resources and political capital necessary to investigate and to make those, difficult sometimes charging decisions and go through with a prosecution of somebody. And so, no, it shouldn't be a matter of we need the media attention, but I can tell you, at least in the circumstances in Chicago, it wasn't just one person who looked up and said, hey, we need to do this. It was because there was press attention, because there was protest, because there were laws that allowed us to do that. Because, it was this whole series, right, of circumstances that really came together in the moment and made reform possible. And the media is a critical component of this. Truth be told, here in Illinois, if the video of Laquan Mcdonald had not been just doggedly pursued by, there was actually well over half a dozen members of the media, it may have been up to a dozen. If they hadn't actually gone to court, that video would not have been released. And we wouldn't have had an opportunity, although it took a long time, to move forward with necessary investigations and police reform and the criminal prosecution.
And I was just going to add one thing is that, the visibility that these cases, because we're talking about Breonna Taylor and George Floyd and Laquan Mcdonald, but these instances have been happening in our country since slavery, since Reconstruction. They have been happening since modern police departments have been around, and there are 18,000 more than 18,000 local police departments. So it's really hard for, that's why when Lisa was saying, each of the state AGs could have this pattern or practice authority. Even with that, and even with every state and local, it's really hard to uncover all of the wrongdoing. So we have to make sure that these that these incidents remain visible, unfortunately. But as far as a prosecutor, it would be unethical, I think, for a prosecutor to take that into account. But as Lisa said, that the reality of the cases.
And the only thing I'll add for Kentucky is Brianna Taylor wasn't the first Black woman murdered by police here or anywhere in the country, but Black women, at least in Kentucky, have not gotten the same kind of media coverage as Black men who've been murdered here by police. So at least for the movement, it was vitally important that we had both the local, state, and national and international attention on Breonna Taylor's murder. Otherwise, and Sam probably can affirm this, some of the small victories and the big victories wouldn't have happened without that kind of attention.
Thank you. Did anyone else have anything to add on that point?
I'd actually submitted a response online to the question, and yeah, I think the unfortunate reality right now is that the higher exposure is going to result in the higher likelihood of FBI and DOJ intervention, which is a problem. But the other thing I noted is that these police departments, and I've got experience with this through actually corrections cases too, these state agencies and these municipal agencies, if they go to the DOJ and say, we want you to jump into this, they're going to do it. So I think some of the encouragement right now needs to be for these agencies to take advantage of that, because these FBI and the DOJ are not going to say, no, we're not going to touch this. If you go to them and say, we want you to go and look at this. We had that happen here with corrections a few years ago. They weren't having any luck getting LMPD to come in and hold these corrections officers accountable. So finally, the director said, screw it, went to the DOJ, and two of those folks are in federal prison as we sit here today, and rightfully so.
Let me just chime in quickly on Sam's comments. I can tell you that when I went to the DOJ and said, we need you to come in to do an investigation of the Chicago Police Department, I was not the first person. This had been going on for years and years, and many requests and many demands had been made by activists, community leaders, church leaders, and other elected officials. And so, they aren't always responsive, or they have not always been responsive historically. They also have resource constraints, and there are also political considerations.
I think both are probably true to a degree. It's certainly true that for the last 4 years, the DOJ Civil Rights Division had very little interest in doing much of this at all. I think, based on what was promised in the 2020 presidential campaign, and also based on sort of knowledge of the folks who've been appointed, thinking about Vinita Gupta and Kirsten Clark, probably a lot more energy and probably a lot more interest in pursuing some of that moving forward, assuming that, the confirmations all go as expected in the DOJ.
Absolutely.
We have a great law school question here. Should state judges raise the standard of review or extend the scope of the exclusionary rules when there is police misconduct and malfeasance? Any lawyerly thoughts on the exclusionary rule?
My thoughts on search warrants and judges in particular are that it kind of piggybacks off of a statement was made earlier that anytime we can be proactive as opposed to reactive, that is going to, I think, give us more fruit and save more lives. I think where I would like to see the judiciary right now, and it's what we're dealing with here right now, is really look long and hard about what their internal policies and procedures are as to the scrutiny of search warrants and as to whether or not these folks should even be going into these houses to begin with. As far as the exclusionary rule goes, I don't know if that's necessarily a judiciary function the way it's characterized in the question. Certainly whether or not the judge is going to execute a search warrant and the policies that are in place with the judiciary in the respective jurisdiction as to the obtaining and execution of search warrants is within their purview. I get it that, if these officers are basically told, hey, even though, you were supposed to knock and announce and didn't, but you got this stuff and it's still going to be able to be presented to a jury. If you take that away from them, maybe it's on their mind, but it's still not going to take away the consequences of that search warrant that maybe could have been prevented to begin with.
And just to add, the exclusionary, it was supposed to be a deterrent for police misconduct. I mean, it does not work. And it doesn't work not because it can't. It doesn't work because there's so many exceptions, judicially created exceptions to the exclusionary rule. And again, judges often just kind of, and a lot of judges, prosecutors overlooking police conduct and saying, oh, okay, they said it, so it must be so. But it was supposed to be a deterrent, and it's not.
Yeah, and so I have next a grand jury question here, and I think Cammie touched on a lot of this in her section. So I'm going to kind of paraphrase it and add my own question to it. Looking at the Breonna Taylor case specifically, we now have 3 grand jurors who have sued Daniel Cameron, saying that he breached the public's trust and misrepresented key grand jury findings. So, insofar as there is a narrative that dates back to at least to Ferguson, probably earlier, that prosecutors use grand juries to kind of hide behind grand juries in order to not have to sort of publicly make the determination that they think is going to be unpopular or bring criticism to their office. Do you think maybe this case in Kentucky is a turning point for prosecutors using, or some might say abusing grand juries in this way?
It goes back to the ham sandwich situation. Prosecutors can indict anybody they want to indict with very limited exceptions to that. I don't think it's a coincidence that if we went and did a study over the last 20 years of officer-involved situations that made it to a grand jury, how many times and what percentage of times they resulted in a no true bill. That is not a coincidence. These prosecutors are put in a very difficult situation where their key witnesses are not going to be there to support them if they go and actually get the indictment that they should be getting. So I think it's definitely a turning point where we can basically at least see that there are problems with a secrecy system when these prosecutors know that anytime they go and present a case that does not result in a no true bill, that none of us are going to know what happened behind closed doors. I think Daniel Cameron's biggest screw up in Kentucky this year is that he talked too much, because obviously if he just played the game and he'd gotten out and he'd said, you know, the indictment was for this and left it at that, we still would be left in the dark as to what really happened there. And none of these grand jurors would have actually spoken. So yes, I think it's a turning point. And I'm having problems with these prosecutors, and with all due respect to them, God bless them and the work that they do, but they're not necessarily acknowledging the inherent problems with the system. And they're just going back to this, you know, this time-honored tradition of grand jury secrecy without basically saying, okay, we can see how there's, you know, issues with public trust right now. We're really going to lobby for more public disclosure. I just think that this is one of those cost-benefit analysis. And I think when you look at the benefits of taking away that secrecy of the proceeding, jury trials aren't secret. They highly outweigh any of the detriments associated with the secrecy protections. That's just my thoughts.
Thank you so much, Sam. I'm going to wrap it up there. We've lost two of our panelists who had to jump to other calls. So I want to thank you on behalf of myself and Representative Scott and the Honorable Lisa Madigan. We have Cammie and Sam still here. I want to thank you again for coming to this panel, for your great questions. I think this was a really fascinating and useful conversation. Hopefully you learned something.